I should know it by memory, but I don't yet. I just rely on my cheat sheet. All right. It is our duty to avoid conflicts of interest and appearances of conflicts of interest in performing our duties as members of this ethics subcommittee and the North Carolina State Bar. Is there any member of the subcommittee that is aware of any personal conflicts or appearances thereof with respect to the matters before this subcommittee today? If so, please so state. None? Okay. As you know, you probably got the pop-up. This is going to be live streamed. And I guess I'll start off by wishing everybody a happy new year. We're still in that after the holidays zone and spirit. So happy new year. We've set aside an hour and a half today, and I feel good about that. Like I was saying earlier before, I think Christina was on. I don't want to jinx us, but I think we're in a good position to really get closer to the finish line. So I want to thank everybody for being willing to take the time through the holidays and now and as much so that we can get as much done as possible before the next meeting. All right, so Brian, you sent us the markup version, which I thought was really helpful so I can see what we've accomplished. And I usually ask you to start off by just saying, okay, where did we leave off and what are our goals for today?
Right.
And then we can jump in and get started on isolating the things we want to talk about.
Yeah, and so I'm gonna go ahead and just share my screen so we're looking at the exact same thing. This is the version that I sent everyone yesterday, and I apologize I didn't get this to you sooner. I was out of the office after our last meeting, and so wasn't able to incorporate everything until I got back. But the big thing, the wrap up from last time, I added some things that I think will be helpful to clarify. One of these things right here, I added a footnote, and I just want to make sure you all are aware of this, that when we're referring to client property, I could absolutely see somebody saying client property encompasses entrusted client funds, right? And I know we talked about this last time. It kind of came up in a tangential way. And so I've added a footnote as well as yet another inquiry to this opinion at the very end. That's a very short one, as you probably saw. That basically clarifies client property. We're not talking about entrusted client funds, and we're talking about client property in this opinion. We're talking about, the original documents of legal significance, the client file, stuff like that, and that we will address entrusted client funds in a different way. So that's just a clarification. I personally think it's a helpful thing. I wanted to get anybody's feedback on that to see if anybody disagrees.
No, I read it and I thought it was helpful.
Okay. Okay, thank you. All right, so the stuff that we added, of course, we added a part in opinion number 5 that basically this was the whole issue of saying that lawyer, if you can't get in touch with your current client, an active representation to notify them about the sale of your practice or the closure of your practice, that you can just withdraw. And so we wanted to make that clear. This is how I accomplished that goal. I tried to kind of weave it into the analysis a bit more, and it just didn't fit. So I have it as a standalone sentence, just to kind of make it clear that, this is an alternative. If you can't get in touch with this person, you can withdraw as well, as long as you're complying with Rule 116, which is our governing rule on withdrawing from representation. We left off talking about opinion number 7 and the documents of original documents of legal significance, and we kind of were going on about how do we define this, and I think we all agreed on the general definition being that these documents, you can't draw a specific definition that everything has to fit into neatly. That it's really kind of whether a document is an original document of legal significance is dependent upon the nature of the document, the nature of the representation for that matter, and basically the question, the absence of that document would cause harm to the client. And so I've kind of incorporated that. I know that was some of your language, Andrea, which I thought was really helpful, and tried to incorporate that into the definition. and made sure that it was clear that when we say that we have client property, like documents of legal significance, that those documents must be returned upon the conclusion of the representation. That was something, this was previously a should return, and I changed it to must, which I think is consistent with the rules. It's much clearer, and it sends that message that we wanted to send. Also wanted to address that question of, well, you might have a duplicate of an original document. And if you have given the original document to the client in accordance with your ethical obligations, you can presume that the client is going to retain it, and that your document, therefore, does not retain its legal significance. We want to kind of relieve lawyers of that burden, I guess, if they have actually provided the original document to the client. So clarified those things, but otherwise, and added this footnote. Again, this was one of those things where I was trying to address this question that we had about, well, what if the document is in the public record? If it's a original document of legal significance, but it gets put into the public record, isn't that something that should be kind of clarified, or does that retain its legal significance? And I think we all agreed that whether or not something is in the public record is really a factor in determining the legal significance of the document. So I put this footnote in here. Again, I tried to incorporate it into the analysis itself, but it felt too clunky. And so I just used it as a footnote, or dropped a footnote here to clarify that, yes, if it's in the public record, each document really needs to be evaluated on its own. And so whether or not it's in the public record isn't determinative, but it's yet another factor in determining whether or not you, lawyer, can or must keep it or must return it. So that's how I addressed all of the different issues that we had discussed last time. As a result of kind of putting this stuff in, I did kind of rearrange what was previously there. Like you'll see this section here, in the present scenario, and it must be noted, however, those paragraphs, those are slightly different from the prior draft, but not substantively. They're just kind of rearranged to make it flow better. So,
that's why when you submit it, you have to underline it as being new.
Yes, because we hadn't.
If it's any deviation from the original. Okay.
Exactly. So, but this is otherwise the same language from the prior draft. So that puts us in a spot. I'm sorry, I'm getting a little visitor from my 5-year-old who recognized the thumbs up, go away sign. Good. So anyway, so that puts us in a spot now where if we're in agreement with this general notion of documents or original documents of legal significance, the definition, and the general notion that this is client property, it must be returned upon the conclusion of the representation, and if you don't return it at the conclusion of the representation, you're effectively acting as a repository. And in that situation, it's that the opinion kind of outlines the considerations, the concerns for selling your practice, namely that you are effectively trying to safeguard this property, that you can transfer it to lawyer B through the sale of your practice if you give that proper written notice, but that the opinion really tries to emphasize transferring this type of property is not preferable. It's the priority should be returning it to the client, but recognizing the reality that not all clients will be located. And if you sell your practice, you're trying to, or closing your practice. And that's the opinion talks about this kind of in the middle of this paragraph that's right in the center of your screen. And just so we can read, let me zoom in a little bit. It's emphasizing the notion that lawyers, when we have client property, we have to safeguard it. We have to keep it in a suitable place of safekeeping. And that can be either, the transfer to the new lawyer via the sale, or sometimes that, we had talked about this. Can you send it to the clerk's office in the county where the practice was located? That was something we wanted to give direction. I remember hearing that at the July meeting of, well, we're basically telling lawyers you have to do something with it. You can't destroy it, but you have to safeguard it. But we're not giving them any sort of direction on what they should do. Not all clerk's offices will accept these types of wills or documents, powers of attorney, whatever it is, but some do. And so the opinion basically advises lawyers to inquire with the clerk's office, to say, I'm closing my practice and I've got original documents and powers of attorneys and all this kind of stuff, wills, whatever. And I'm wondering, can I register them with you? So somebody, the person that I could not find, and I've tried to find them, the person I could not find, if they want to get this document at some other time, they can do that. It really kind of, it's, to me, it brings up the general notion that, for entrusted funds, we have the escheat process, right? And that's a great process where you can identify the funds, they can be held for the client whenever they come and collect them. But this type of property, documents, we don't have an escheat process, and it's not clear exactly what you're supposed to do, but the opinion, again, tries to give some direction on what a lawyer can look at and kind of go from there. So I'll stop there before we get in, because we start to get into the other ones that are, I think they become kind of a cascade of opinions. I want to just stop here and see, does anybody have any problems, concerns, et cetera, with the opinion at this point?
All right. And I see that Warren and Stacy have joined us. Happy New Year to both of you.
How are you?
So, yeah, if everyone can just, if you have a comment, we'll go through and make sure everybody has the ability to ask questions or to, and I see, Julie, that you have, or Judge Bell, sorry, that you have your hand up. So we can start with you. But what I'm hoping for at this point in the process is for us, if we have certain scenarios, and Brian, hopefully you're okay, we're going to put you on the spot. But I've got like a list of certain scenarios that I thought we could kind of test this and see if we walk through the scenario, what the answer would be. So we all feel comfortable with that. So if you have some ideas about what scenarios might come up for people, maybe we can try that and see if that works and helping us feel good about what we have. All right. So Judge Bell.
And it was fine for you to call me Julie. I appreciate it, but all is well.
Because I was going to call you that.
Yeah. Well, my father was a judge for many years and I always called him Dad. So
I'm just saying, I don't get hung up on that.
Okay.
If I'm on the bench, that's fine. But if I'm not on the bench, that's different. My only question, or maybe it's a thought, was someplace in here, it seems to me that we've addressed what happens if lawyers, we've said that lawyers have a duty to return clients' original documents, and that if they don't, then they have a duty to protect them. And we've laid out some various scenarios. I wondered if we want to put, and if that's in there, I missed it, some language that says it might be preferable to return clients' original documents so that it relieves you of that duty. And I understand, I think when we originally talked about this, Andrew, I think you were talking about in your practice, a lot of clients sometimes want you to retain an original will to become the repository of it. So I didn't know if there would be some pushback on that. When I was in private practice and did wills for people, I would always give them the original and only keep a copy. And then I've had occasions where relatives of those clients would call and say, do you have the original will? And I'd say, absolutely not. And I was confident that I didn't have, because I think it just, some sort of comment like that might let lawyers know, hey, you're going to put yourself in better position if you don't have these original documents. But I didn't know if there would be some pushback from a practice where clients expect you to keep the original. So that was, I just wanted to raise that.
So Brian, did I don't have the document, but didn't you have it where it said must return, as a general rule, lawyers must return client property?
That's right. And that's this paragraph where we basically say, yes, general rule, lawyers must return client property, including these original documents of legal significance, at the conclusion of representation. And really it goes on to say, although lawyers may retain a client's original document as the method of safekeeping, it's the recognition that lawyers in their practices are subject to a number of different things that can happen that can threaten the preservation of these significant documents. And so that's where we conclude that clients and lawyers are best served by having the client's original document, the legal certificates, provided to them upon the conclusion of the representation to ensure the client has control of the document safekeeping. And then we kind of kind of say it again, when we're talking about the question presented in the opinion is the transfer of these documents. What are you supposed to do when you're selling your practice? And so we recognize that, yes, a lawyer can transfer these documents through the sale of practice as long as they provide that written notice. But then I thought it was important to put here that it must be noted that transferring such client property is not ideal because of the nature of this property, and returning the property to the client should be prioritized. So that's where we try to kind of hit it in two different ways and try to really send that message. Get it back to the client. Do it at the outset when representation terminates. But even if you've held on to it, you should really prioritize getting the document back to the client as opposed to giving it to someone else.
Thank you. So it sounds like we hit it fine. Thank you.
Yeah. So this is a good time. I'm just going to interject this into the discussion. So with returning documents, is it addressed in here? I don't know that it is, but I know we talked about it in the past, and that is, especially with wills, sometimes lawyers will have two sets of originals. And I think you did address that, where if there's two originals and the client has one original, then the original that we keep is not considered an important document of legal significance. Is that correct?
He's got it on the screen right now in the yellow, highlighted yellow.
You're muted, Brian.
Yeah, sorry, I was muted because again, the 5-year-old is hungry. So,
that's all right.
That's why we put the applesauce and yogurt, down on the lower shelves. I mean, come on. But anyway, so I put that here. This is the, I guess and to your point, Andrea, the duplicate thing, when we were talking before in our prior meeting, we were talking about kind of two sets of duplicates. There's the duplicate original, two different wills, but then there's the kind of the copy of the will, or the copy of the contract. We have multiple copies and all that. And clearly the original is the one that has the legal significance. But I tried to just kind of state here that, yes, if you have a duplicate, and I guess I kind of meant it to be a duplicate of any kind, whether it's original or whether it's a copy that you still think is valuable, because if the client loses the original and they need a copy and they can somehow try to submit that as evidence of the agreement or the intent, that essentially when you give that original document to the client, lawyer, you are relieved of the burden of thinking what I'm retaining has legal significance such that I must continue to safeguard it. I think that would be, it feels like, the opposite conclusion would leave a lawyer in a position where no matter what it is, if it's a significant document, they always have to keep it. And I don't think that's necessarily fair. I think if you give it to the client, you're allowed to wash your hands of the matter.
Okay. All right. So the other note I had was, this is a hypothetical. So if a practice has a will from the 1970s that is in our drawer or somewhere that's being safe, in our fireproof safe or wherever we decide we want, we're keeping those documents. And it doesn't necessarily have to be a will. It could be something else, but we become aware that our client has died, not recently, but in the distant past. If we can confirm that through a newspaper article, through an obituary, something of that nature, what would be our obligation under this in that scenario? And do we need to address that?
Right. And that's, we've been presented with that before in ethics inquiries. I think I guess I have two kind of feelings. One, the response that I've given to folks is, if you know that the person has passed and nobody has come to collect the will, and that essentially probate has started, and this is easier in some counties than others, clearly. Maybe if you're in a smaller county, oh yeah, I heard that the estate is resolved, it's closed, all that kind of stuff. And there's a fair presumption that they must have had a different will. drawn up or whatever, and I just didn't know about it. I have told folks that basically if you feel satisfied that the document that you're retaining is no longer legally significant because everything is done, then I think it's fair to conclude that your document is not legally significant and you can treat it as such. That's no longer client property that you must safeguard. I try to encourage folks, though, to take some steps before you destroy that document to make sure that you feel comfortable the estate has been opened and closed and everything's done. They're not using a will that predates this one that you drafted up, that sort of thing, to the extent that's, again, reasonably possible.
So that's a good connection to, so you've done that analysis, and I'm assuming you've pointed to this ethics rule and these opinions to support that analysis when people have called. So my question is it worth it? And I guess this would be to you and to the committee. Is it worth it to have some specific reference to this, or do you think it's so uncommon that it's not necessary?
I mean, I'll offer an opinion first. As far as this opinion, I think if we wanted to address it, I don't know if this is the opinion for that. It's related, but it starts going off in some of the different shoots that, you can draw. I mean, there's so many different directions that you can go with this opinion. And so if there's any confusion, from our prior opinions or anything like that, then that might be just a different opinion. But I don't know. I mean, it's not something that's terribly uncommon, at least as far as what we hear. And I don't know, Warren, you probably deal with this with all the different lawyers that you guys come across. Maybe you have a different perspective, but I don't know if anybody else has a similar feeling that I don't know that I don't know that we need to address it in this opinion, even though it's clearly a relevant question. I can't say that we get that question all that often at the bar, at least.
Okay.
Yeah.
Anybody have any thoughts on that? No. Okay.
I mean, I guess maybe you could have a parenthetical to that yellowed sentence there, highlighted sentence that says, if a lawyer provides his client with his or her original document of legal significance and retains a duplicate copy in the lawyer's client file, or the lawyer after reasonable concludes that it's no longer legally significant, or something like that. I don't know. I'm inclined to leave it as it is and let Brian address that. Can I point out one sort of typographical thing I just sent you? In the final sentence of that first paragraph, on the other hand.
Yes.
On the other hand, the client files stemming from the real property closings, however, will get rid of the however. Does that make sense?
Yep.
There you go. All right, cool.
Thank you.
All right.
All right. Does anybody have any hypotheticals that they think kind of tie into where we are right now that you want to raise? Yeah. Okay. All right. So I have a few more. And I know we've talked about this in the past, so I just want to make sure that we've properly addressed it. So real estate files that have old plats that have not been recorded. The real estate file might be 20, 30 years old. Clients are long gone. How would you address that, Brian? How would you respond to that? Like, if we're trying to close a practice and we've got these old plats in that scenario, what would you what would you point to for us?
I would, see, and that's where this opinion helps in the advice that we give, because when we get those types of questions, and this kind of ties into the last hypothetical that you posed, that we're really defining or trying to define, is this a document of legal significance?
So that's the overarching question. That's like the threshold question.
Yes,
for
yes.
everybody
That's
is
everyone. We're talking about plats, or we're talking about a will. You know, you find out that the estate was open, closed, and it looks like they used a more recent will or whatever. You've done some reasonable inquiry and see that, yeah, they don't need mine anymore. It's no longer legally significant. And I think it'd be the same thing if you are if you have a real estate practice and you're closing on these files. You have 30-year-old files that have these plats in there, and you're kind of like, well, this isn't legally significant anymore. And that would be a question. These are questions that I end up usually throwing back on the lawyer, because, you know, I'm not a real property practitioner. So I have to ask them, what's the effect of this? If you threw this away, if you destroyed this file, would that be to the detriment of the client? Would it thwart the purpose of your representation? And a lot of times I say, well, no, I wouldn't. I feel bad throwing it away because maybe they want it, but I don't think it's really effective anymore. It's not something that they need. And I feel like that kind of answers the question about the legal significance. So it's all in that question, that threshold question. Is this an original document of legal significance? And if it's not, then to me, it's now just a document in the file that's eligible for destruction.
Got it. And I guess that's the way that you would present it to the full committee when we're talking about this, is that's the analysis.
Yeah. And I think that's one of the things with our opinions and just the ethics process in general. You know, we're looking to give guidance to lawyers to exercise their judgment in their particular practice area. And I think that's the nice thing, what we're doing here, of actually defining and trying to offer some thought on what is a document of legal significance. I think this is a really helpful thing to lawyers, that they can look at and say, the absence of this document, is that going to harm my client? No, it's not. Okay, well then you're good. And I think that's going to be a really helpful tool. But that's going to be a lot of those things that we provide, the advice we provide, opinions we draft. They do kind of put it back on the lawyer. You know the parameters of the thought, and now you need to apply it to your particular situation based upon your knowledge of the practice area, the client, et cetera.
Yeah. And I guess, you know, once you get past that first threshold of whether a lawyer believes in his or her opinion that it's legally significant or not, then the next question is, the due diligence that the lawyer has gone through to try to get it into the client's hands. And then the ultimate question, if it ever becomes an issue, is, can the lawyer defend what they've done? And can they defend their analysis, to back up that? And I guess that's going to be the whole process, right?
Yeah. I feel like that's when Warren and his claims counsel comes in, and when somebody sues for you never gave me back that document. But it's that thing. I think if a lawyer was following this opinion, and if they truly followed every step, and they got sued by a client that says, I can't believe you sold that practice and got rid of that file, you destroyed it or whatever, and the lawyer can go back and say, I read this opinion and I sent a notice to you at the last known contact address, email, mail, whatever it was. I've tried to get in touch with you. You never responded. And it's over. Not only is it over 6 years old, so I decided to destroy it because I didn't need it, or I transferred it to this other lawyer. You can go there. It's not legally significant, because if it is legally significant, then the lawyer has that obligation to either return it to the client or to safeguard it, safekeep it some other way, which hopefully that means if they sold their practice, here's the person who's holding it.
Right.
So it should create a scenario that really, I think, looks good for the lawyer that's being accused of being negligent with their documents.
Yeah. Does anybody have any hypotheticals that they want to make sure are properly addressed at this point? No. All right. So I have my own notes and questions I wanted to present to you, Brian. This is a question to you, but also to the committee, because I don't know if we talked about this part, but when I was reading this, I was wondering if we should include some reference in the heading of the opinion that this also addresses scanning files. And, when we're converting this generation, maybe future generations, it's not going to be as important, but now we've got a lot of practices that are converting files from hard copies to scanning them and having it in the system. And I'm just wondering if we should include some reference to that to help attorneys who are going through that process, give them some guidance on, you know, what they need to do when they're going through files and trying to scan.
Yeah, we do have some an opinion on that. I don't have it off the top of my head though.
Is it,
no,
so it's a
Warren is my
separate,
fellow
it's a
ethics
separate opinion then? I
It
wasn't
is.
aware of it. I'm sorry, that's my
Yeah.
bad. But,
No, that's fine. But that's to your point, you know, there's that question of, and I think this is the issue with all the ethics opinions. You know, you can put these little segues, you know, just little indications, because you're looking at this one. Is this an appropriate place to reference this other
Yeah.
opinion? Because you're reading this one, you're like, you have that exact question. Well, what do I do if I want to scan everything? Do I have to keep it? The general answer is, if you scan everything, of course, we're not talking about original documents, right? We know that. But if we're just talking about files and you scan everything and you can preserve it in a reliable way that's easily accessible, you can get rid of that paper file, even if it's before 6 years, because you have the digital copy. If that digital copy is sufficient, then you're good.
So I was like, the way I was looking at this was, this opinion to me was a really good roadmap already for people who want to scan or who are in that process of scanning.
Right.
So it wasn't necessarily changing anything. It was just, is there a way, and this might be overkill and you might say, no, just leave it alone. But I was just wondering if there was a way to just reference the scanning so that it could be a good, you know, a good rule for the ethics attorneys like Nicole or whatever to point to.
Yeah.
I don't know. Or if we're looking and we're doing word searches or something.
Yeah, I think so to me, this is an opportunity for a reference where, you know, and I'm looking through the opinion and I'm thinking it might be, we could put it in one of the earlier opinions that it's an aside, right?
Mm-hmm.
It's just kind of an opportunity to say, when you're transferring information, client files, etc., you know, you have a duty to send that notice. And we could make this aside there that, you know, whether we're talking about hard copy or scanned digital copy, C20, I think it's 2013 FEO 15. And we could just have that reference. So somebody says, oh, scanned electronic storage or electronically stored files. Let me look at this opinion. It could be something as simple as that. So, and I don't think that would be too much to, you know, kind of introduce some other unrelated thought. It's a related thought, and it would be quick enough that it wouldn't be distracting. If you all think that'd be a good thing to include.
Does anyone have any aversion to doing that? No. Okay. As long as, Brian, I'll just trust you. If you feel like it was overkill, but I just thought because it was so relevant, then, you know, it might be worth just that one mention.
I'm looking at a part. I would want to kind of look at this and, you know, play around with it, make sure that I have the right language and that it flows properly. But I see a spot in opinion number 3 that I think it could go. And like I said, it'd be a very quick spot, not distracting in any way.
Okay. All right. The last thing, I think this was the last on my notes. No, I have 2 more things. So just to confirm, a client, we send something out to a client, we're ready to purge a file, we send something out to the client, where we notice that there's some originals in there that we didn't know about. And the client says, like, and here would be an example, a tax return, an original tax return. We send an email to the client and say, we're getting ready to destroy your file. It's been 6 years. We've got a tax return that we realize is here. And they send us an email back saying, you're fine, you can get rid of it. That's enough, right? Under this?
Yes.
Okay.
Yeah.
All right. Just wanted to make sure that was covered. And then I don't have it in front of me because I can't figure out how to pull up the document and keep the Zoom, keep everybody's faces at the same time. But can you just pull up number 2?
You talking about opinion number 2?
Yes, opinion number 2.
Okay.
We can look at it, because I had one thing I wanted to point out on that. Okay. Just give me a second. I got to find the place. Okay, so that just to get everybody focused, because this is completely changing gears. This is where we talk about when you sell a practice, and you're selling a practice, and then there is that 100-mile radius where you're not allowed to practice within the 100-mile radius if you sell a practice. We talked about this in one of our earlier meetings. Right. And then we put some exceptions. So where it says, as an exception to the general prohibition, Rule 1.17a allows the seller to continue to practice law with the purchaser and may provide legal representation at no charge to indigent persons or to members of the seller's family. So those are the exceptions. And my question is, should we put and or and make it clear that it's, so it says continue to practice law with the purchaser, but that could be one option. Another option would be providing legal representation at no charge. I mean, can it be and or? I guess that's my question. Or do we not want that to be and or? Because I'm wondering.
That's quoted right out of the rule, though. So, I mean, if he wants to keep it a quote, right?
But do we want to change it? Like because we were concerned that it was too limited.
Well, yeah, I think to your point, Andrea, so this provision in the rule, I have always read this, and I don't know if you all read this differently. I see what you're saying, the and or thing, because you could read this and say, I can continue to practice law with the purchase and provide legal representation to indigent folks or members of my family. Is that supposed to be in connection with practicing with the purchaser of my practice? I don't think so. I see it as two different things. It's you can practice with the purchaser. Also, you can provide no charge or basically, pro bono representation to indigent folks and folks that you are related to. It is two separate.
So it's three different scenarios then.
Yeah, yes.
Okay, so and I realize that's a quote right out of the rule, but is that something that is worth just trying to clarify through different punctuation? That's all I'm asking.
I think so.
Maybe worth revisiting, clarifying that rule.
Oh yes, let's issue the opinion first.
I agree. I certainly don't want to do it if it requires a subcommittee.
I think I see what you're saying, Andrea, that this is an opportunity to clarify that there's different scenarios.
And to Andrea's point here too, the pro bono work is not just to indigent persons, but it's to pro bono work for your own family too, right?
Or can you charge your family?
Or can you charge your family members for your work? Is that clear?
Yeah, does it have to be free to your family?
Right.
It shouldn't.
It shouldn't, but if you read it.
All the power to an attorney who can get paid by his family, but.
Right.
Yeah. But nonetheless.
I mean, would that be?
Let's say your family has a business. And you're.
I was thinking of saying continue to practice law with the purchaser, comma, provide legal representation at no charge to indigent persons, comma, and or provide services to members of the seller's family.
Yeah.
I like that. And just take the quotation marks off of it.
Mm-hmm.
I just take them. Okay. Yeah, I can do that.
And I think that solves my concerns.
All right, I'm gonna highlight this just for my own purposes so I can come back and clean it
Okay.
up, make it look nice.
Okay. All right, so at this point, that's all I had on my list. At this point, I want to ask if anybody has any thoughts, scenarios, or things that they want to vet with this, these new rules or amended rules. No,
I think it's ready to go back to the full ethics committee.
yeah.
Agreed.
So
Or is it
Brian
authorized practice? Yes, I
is,
think.
I mean, I feel really good about it. I feel like, you know, through these meetings, we are getting to a point where we're just we have less and less concerns and less to say, obviously. So that's a good sign. Does that mean now that this committee would have to, do we actually have to vote or?
Yeah, that'd be helpful. The vote is one of those things. The vote officially occurs at the full committee, and really we would need somebody from the subcommittee to move the publication of this opinion. If we are all in agreement that we're ready to support this opinion for publication, then I don't know that a vote is necessary.
It's not, we don't need that
procedurally
formality.
Exactly.
We can do this by
It's-
consensus. If anybody
Yes.
has any objections to sending it to the full committee, then, you know, I don't think we do. I'm looking at everybody's faces. Everyone's nodding their heads. So I'm going
Can
to
I
take that.
interject one thing? I'm sorry.
Sure. Yeah, no, please do.
No, and I appreciate the addition, Brian, of the reference to if documents are available on the public record, because that kind of took away one of my concerns was, what if I got rid of the original, but the client had to pay for a certified copy, which I would consider a minimal concern, but you know, someone else may not. I'm still struggling a little bit with the harm to client concept. I would rather say something to the effect of that it's that the absence of an original results in a nullification of the legal significance, or even maybe say, instead of cause harm to the client, say is a detriment to the client.
Material, or put something material, because I agree with Christina on that.
Yeah.
To the extent
That's a good point, Christina.
that
Thanks.
you know, it harms me because I got to go to Kinko's and make a copy of. I mean,
Right. The materiality concept
Right.
is what I'm looking for. Thank you, Warren.
I like that.
All right, so we're talking here, this is where I think this is the language that we're looking at. Conversely, destruction or absence of such documents prior to the termination of the document's value would thwart the purpose of the representation, would damage the client's legal position, cause the client to experience a loss, and or would generally cause harm to the client. And so I think what I'm hearing you say that it would be detrimental, instead of maybe damage the client's legal position, it'd be detrimental. Would that be preferable?
Yeah, and I like what you've got there, that you've got some choices there, the thwarting of the purpose of the representation, damage to the client's legal position. I wonder, the cause harm is what are the two words that are kind of bugging me.
Harm is in the eye of the beholder, in other words.
Yes, and if we introduce a materiality concept, maybe that would address it. I'm not sure. I'm just still struggling with how that's going to be interpreted long term.
So do you think and so I see what you're saying here, and you know, we could, if this is causing us a little bit of heartburn, we could simply get rid of the cause harm. I think
Let's get rid of it.
Okay, but let me see. That's fine with me. And Christine, I think that's an excellent point. Thank you for bringing it up. So, but something a word came to mind. I don't know if this fixes it, maybe not, but if it would generally cause irreparable harm.
I think, yeah, that introduces the materiality.
Yeah.
Or maybe you say material and irreparable.
I see what you're saying. I was about to add material to the definition when we're saying such documents have an inherent value. You You know,
Inherent
it's almost
material value,
like
is
a
that?
material value, but it is an inherent and material value to the representation. But I'm wondering where, if maybe it would be better, it would generally cause material irreparable harm.
Yeah, I mean, because when we have situations that might come up, I mean, I don't know how everybody else handles this, but when we have something come up in our practice, a lot of times it's like, is it fixable? The question is it fixable or is it not fixable? So irreparable would be like something that you can't fix. And a lot of our statutes can make it so it's not irreparable. Like, for example, you know, with a will, if you don't have the original will, but you have documentation that that was in fact the last will, or evidence that that was the last will, the statutes address that, and they allow you to submit a copy of a will for probate. Same thing with you know, with copies of contracts. I think that there's some statutory provisions there. So anyway, just that's what I thought, you know,
to that end, is irreparable, is that perhaps is that overbroad? Because like you said, like we don't want to give lawyers the green light to just get rid of the original will when that is clearly going to be the thing that you should keep, even though the statutes allow an avenue to get around that if you have a copy and can show the, you know, to show that evidence. We don't want to just rely on that. So maybe is it material, would cause material harm? Because I think if you got rid of a will,
yeah, I mean, it's going to cost you more money, and it's more time and more aggravation, and there's more risk at submitting a copy of a will because the clerk has to approve it. So,
right.
I mean, I'm okay with taking out irreparable and just going with material.
What do you all think, Christina?
Or taking out, I mean, if you don't have heartburn about taking out that whole part, I mean, what I'm with Christina on this idea that harm, I don't know what's material. It gets,
so
just because we're talking about the loss of the ultimate objective of the representation, right? That they hired you for some ultimate objective, and if the destruction of that document defeats the ultimate objective of the representation, then it's a document of legal significance. But just because they might have a harder time finding that document from some other source or somewhere else does not make it legally significant, even though they might be harmed in doing that. And we're really just talking about, otherwise we get into nickels and dimes on what does harm mean, and where does materiality start, and things like that. To me, that's, we're really talking about a limited number of things.
This is hair splitting, but that's what we do, right? So I'm looking at thwarting the purpose of the representation. I don't think that's enough, because we could come into possession of documents that are ancillary to the representation. And so I feel like thwarting the purpose of the representation might be too narrow. So damaging the client's legal position, again, I think could be too narrow. Causing the client to experience a loss and or generally causing material harm, I think those might be the same thing. So maybe we pick one or the other.
Yeah, at the very least, I'd want to add material before loss as well.
Yeah. But I'm personally okay with the use of material. I mean, there's so many situations as lawyers that we have to define that. I think I'm not so spooked by that.
I agree that we don't need both material loss and material harm. I think pick one, and I think material loss would be better.
I agree.
All right.
Yeah.
All right. So if I did this and add the and/or, how's that look?
I'm good with that.
And I think that kind of gives the out so that we don't say any possible harm. I think it makes it better, because I understand Christina's point that it seemed like we were hanging people out to dry for any concept harm. You know, is the harm I got to go find another copy, or I got to do, you know, something else.
Okay.
Agreed.
All right.
Okay.
Any other comments from the gallery?
So if I can, since we're sharing the opinion right now, I want to make sure that I didn't hear anybody talk about it. So I'm just going to make sure that we're all good. You saw I added this inquiry. This is for the last time we looked at this draft. We were talking about, well, what if a lawyer isn't trying to sell their practice? They're just closing their practice. That's what inquiry and opinion number 10 address. That essentially says, you know, like, do you have to comply with the same written obligations? Well, it depends. And it just kind of goes through when the written notice obligations or written notice requirements apply, when they don't, destroying files and all that. It's a pretty straightforward, excuse me, and non-controversial opinion. But again, it just kind of reframes it in the context of, I'm not selling my practice, I'm just closing it.
Right. And I think that's what we talked about at the last meeting,
Yes.
and it was consistent with what I was expecting.
And then I added this last time based upon somehow it came up the notion of, well, entrusted funds are a little bit different, and basically saying, like, lawyer is leaving, can you transfer it to lawyer B or any other third party, whether you're closing or selling your practice? And the opinion that I put in here is that the client needs to consent to any sort of transfer of entrusted funds, or you escheat. If you can't get the client to consent, you have to escheat. You can't transfer it to lawyer B if that client doesn't give their consent. I think that would be something where you just remove it from the sale of the practice. Maybe the information goes to client B, or excuse me, to lawyer B, but the funds get escheated to the state, and just leave it with the escheat process. That rule 115-2R kind of overrules or wins the day on that question. So.
Okay. All right. So I'm just still trying to see if anybody has any thoughts, comments, questions. It looks like Missy's on now. Hi, Missy. I think she's with us.
Yes, you guys, I'm so sorry.
Yeah, you're fine. Don't worry about it.
Traveling home from court. And if you guys ever want a problem solved, show up 45 minutes late and have you wise people solve the problems. Thank you.
Okay, so Missy, if you had a chance to read what Brian sent us a couple days ago and you wanted to address something, I just want to give you an opportunity to bring it up. So if you had any questions or anything, you can get those answered. We're kind of we're arriving at a point, fortunately, where we're ready to tell them to send it to the full committee. So this is kind of not your last chance, but a good opportunity to jump in.
This is a speak now or forever hold my peace, and I am going to forever hold my peace.
Okay. All right. So, so Brian, I guess the next step is for us to acknowledge that you're going to submit it to the full committee and let them vote on whether to, if it's ready for publication, or whether they send it back to us, right?
Yeah. So what we can do, based on the conversation, the seeming consensus here today, I'll put it in the agenda with the indication that that the subcommittee is going to recommend its publication at the full meeting. Since you will be over in grievance.
I was going to address that. I mean, I'm assuming that you will do the presentation, but what I was going to ask is if anybody wanted to volunteer to kind of be take the lead if there were any specific questions of the subcommittee that you couldn't answer or didn't want to answer, Brian. Does anyone, because I just Brian knows this, but I'll be in grievance this year. I'm going to be on the grievance committee, so I won't be in ethics.
So 1 year of ethics was all you could take.
It was. I'll tell you that at the beginning I was a little skeptical, but the more you delve into ethics, I mean, at least my experience, the more I enjoyed it. So, I'm glad I had a chance to experience it for sure.
Very funny.
And Brian, I mean, well, of course, Brian's great to work with, but so are you guys.
You're kind.
But no, seriously, does anybody want to volunteer just to take the lead in case it's necessary? I don't know. I think Brian can probably handle it on his own, but
I'll offer the presentation, but I know that Catherine Fry is our new ethics chair, and she will probably go through the list of subcommittee members just to say, what do you all think? Call on the subcommittee members. And so that means that, just alphabetically speaking, Judge Bell, you'll probably be the first person to be called on. So yeah, I think at that point, any subcommittee member that wants to go ahead and say, we worked on it, and I'll make the motion to publish. That can be as simple as that.
Okay. That sounds good.
I kind of view these things, when we talked about, well, if somebody had a problem with it, when we come to consensus, it's kind of my feeling, if we're in consensus, that I wouldn't expect anybody on the subcommittee to then challenge it when it went to committee if we're in consensus. Now, if we take a vote and there are people who have dissenting opinions, that may be something different. But when we're in consensus, from my perspective, the members of the subcommittee don't then go to the committee and start saying, well.
Right. But there might come an opportunity to defend what we did if people start asking questions and they don't.
Defend. I just don't expect when we have taken a subcommittee consensus, not a vote, but we said, hey, has anybody got an issue? No, we don't have any issues. Y'all wouldn't expect me to then be in the meeting going, well, I think we need to change this by doing X, Y, Z, because then it's like, wait a minute, why didn't you say that in subcommittee?
Yeah.
Correct. 100% agree.
Since we're recommending it for publication, my guess is that we'll get feedback and bring it back. But Andrea, you're not going to be on anymore. I'm rolling off. Warren, are you sticking around? You're sticking around ethics?
Oh yeah.
Well,
Warren, I'm not really ethics.
I'll be on ethics too.
So let me say this: I am going to continue to be chairing the subcommittee. I've agreed to do that because I felt like I wanted to, take it through to the end on that. So the only thing that I won't be able to do is participate in the ethics meeting, the ethics committee meeting, because that just conflicts with the grievance meeting. So on every other level, I'll still be involved, and we'll just see how it goes. I think ethics is that is live streamed, right, Brian?
Well, if we can get, sometimes it is. We've been trying to get the technology to work, but our Wi-Fi signal is just not good in the bar. So we're hoping to improve that this year. But I think the big thing, if we publish this, of course, if anybody has questions at the full committee meeting, then a variety of us can speak to that. I'll be happy to speak to them. Other subcommittee members that are present can address that. But whenever it gets published, whatever feedback we get, I'll be monitoring that feedback. And if we get some really strong opinions that I will, for one, anything we get back, I'm going to share with you all. And we can decide at that time, do we want to meet before the April meeting to talk about this stuff and say, we looked at it and we don't feel like the feedback really requires us to change the opinion,
right.
Or there's some good points here. Maybe we need to talk about some of these things, and we'll recommend to go back to subcommittee. But I'll be in touch with this entire group. Missy, you're not getting rid of us that easily. So we'll still be in touch whenever we get everything, and just kind of see what the next step needs to be.
Yeah, and no, I appreciate everybody who is not continuing on ethics to to be willing to kind of continue to serve, because I like the continuity as opposed to trying to get everybody else up to speed, so, or anyone else for that matter. So all right, I think we're at a point where we might be able to leave early.
Yeah, I think I'll go ahead and clean this thing up, have a clean copy. I'll include it in the agenda. Andrea, I'll be sending you some reports, the minutes of these past two meetings for your review. But otherwise, we'll be good to go, and we'll send it to the full committee, see what they have to say.
Okay.
Sounds good.
So, does anyone want to make a motion to adjourn?
So moved.
We're out.
Okay. All right.
Thank
I'm
you.
just going. I'm going by nodding. The head's nodding up and
Yes.
down that we're good to adjourn. Okay.
We are.
Thank
All right.
you.
I'll see everybody in 2 weeks.
Yeah.
Sounds
All
great.
right.
Cool.